Okay, hello, good evening everyone. Now we are going to proceed with alternative obligations. From the viewpoint of the number of prestations involved, an obligation may either be simple, where there is only one prestation, or compound, where there are various prestations. The latter, in turn, may either be conjunctive, where the prestations are demandable jointly or both at the same time, or distributive, where one of the various prestations may be demanded. Take note that a distributive obligation, in turn, may take the form of either alternative or facultative. There is no problem with a simple obligation because the obligation is extinguished only upon the performance of the prestation. There is likewise no problem with a conjunctive obligation because the obligation can only be extinguished upon the performance of all prestations included in it. That's why we are going to discuss the two forms of distributive obligation, the alternative and facultative. In an alternative obligation, there are various prestations which are due, and the obligation is fulfilled by performance of one of them. In an alternative obligation, the obliger must completely perform one of the prestations due, and he cannot compel the creditor to receive part of one and part of the other undertaking. Example, D borrowed from C 10,000 and it was agreed that D could comply with his obligation by giving C a 10,000 pesos, a color television set, or by painting the house of C. The rule is that the right of choice pertains to the debtor. The creditor may exercise the right only when the same has been expressly granted to him. But this right is subject to limitations. And what are these limitations? First, the debtor cannot choose those prestations which are impossible, unlawful, a second unlawful, or the third which could not have been the object of the obligation. The choice becomes effective only from the time that it has been communicated, since the civil code is following the cognition theory. The choice made by one becomes binding upon the other only when the latter gains knowledge of such choice. Take note that the notice may be in any form, provided that it is sufficient to make the other party know that the election has been made, while there is a decision to the effect that the effects of the choice will arise only if such is consented to by the creditor, or if being impugned by the latter is declared proper by the court. It is clear from the law that the consent of the other party is not necessary. What the law requires in order for the choice to become effective is a mere notice, notice to the other party. Indeed, if the consent of the other party is required, the essence of the right to choose and the alternative character of the obligation are destroyed. From the time the choice is communicated, the obligation ceases to be alternative and becomes a simple one of performing that which has been chosen. Of course, when among the various prestations only one is practicable, the debtor loses the right of choice and the obligation becomes a simple one of performing that which is practicable. Now, if through the creditor's acts the debtor cannot make a choice according to the terms and conditions of the obligation, the latter may rescind the contract with damages. Now let's proceed with the effect of loss of prestation if the right of choice belongs to the debtor. Okay? If one or some were lost by reason of fortuitous event, while several others remained, the obligation is still alternative, and the debtor may choose from those remaining. If one or some but not all were lost by reason of debtor's fault, debtor may still choose from the remaining. However, if all were lost by reason of debtor's fault, the creditor now is entitled to recover the value of the last thing which disappeared or that of the service which last become impossible with indemnity for damages. Of course, if the cause of the loss is a fortuitous event, the obligation is extinguished. Now, where the right of choice belongs to the creditor, if one of the things is lost through a fortuitous event, he shall perform the obligation by delivering that which a creditor should choose from among the remainder, or that which remains if only one subsists. If the loss of one of the things occurs through the fault of the debtor, the creditor may claim any of those subsisting, or the price of that which, through the fault of the former, has disappeared, with a right to damages. If all the things are lost through the fault of the debtor, the choice by the creditor shall fall upon the price of any of them also, with indemnity of damages. Now, in a facultative obligation, only one prestation is due, and that to which the obligation refers, but the debtor has the power to fulfill the obligation by giving or rendering something else. Let us distinguish facultative obligation from alternative obligation. According to prestation, the loss of the thing due, and right of choice. In alternative obligations, all the things or objects of the prestation are subject to the obligation up to the time the election is made, whereas in facultative obligation, only the thing promised is subject thereto, but not the other which the debtor has reserved to himself the right to deliver in lieu of the first. Second, loss of the thing due. In alternative obligation, as all things are due, the loss of one produces, or at least may produce, a deleterious influence on the obligation. Whereas in a facultative obligation, since only one thing is owing, the loss of that thing which may be substituted does not affect the juridical relations. Furthermore, in alternative obligation, the right of choice may be granted not only to the debtor but also to the creditor, whereas in facultative obligations, the choice to substitute lies only with the debtor. As to the effect, of loss of substitute, if the loss was prior to the substitution, okay, at which time the substitute is not what is due, the debtor is not liable even if the loss or deterioration of the thing be by reason of his default. But if the loss or but once a substitution has been made, the obligation of the debtor is limited to the performance of the substitute prestation. Hence, the loss of the substitute on account of the debtor's delay, negligence, or fraud shall render him liable for damages. However, if the prestation is lost by reason of fortuitous event, without any fault on the part of the debtor and prior to him incurring delay, the obligation is extinguished. Okay, we have here an actual case of Arco Pulp and Paper Company Incorporated and Candida A. Santos versus Dan T. Lim, who is doing business under the name and style of Quality Papers and Plastic Products Enterprises as the respondents. If you would want to browse over the case, its GR number is 206806. Okay. So the facts of the case are as follows. Dan T. Lim works in the business of supplying scrap papers, cartons, and other raw materials under the name Quality Paper and Plastic Products Enterprises to factories engaged in the paper mill business. Okay, then Lim delivered scrap papers worth 7.2 million to Arco Pulp and Paper Company Incorporated through its CEO and President Candida A. Santos. Now, the parties allegedly agreed that Arco Pulp and Paper would either pay Dan T. Lim the value of the raw materials or deliver to him their finished products of equivalent value. Dan T. Lim now alleged that when he delivered the raw materials, Arco Pulp and Paper issued a post-dated check as partial payment with the assurance that the check would not bounce. When he deposited the check, it was dishonored for being drawn against a closed account. On the same day, Arco Pulp and Paper and a certain Eric C. executed a memorandum of agreement where Arco Pulp and Paper bound themselves to deliver their finished products to Megapack Container Corporation, no, owned by Eric C. for his account. Now, according to the memorandum, the raw materials would be supplied by Dan T. Lim through his company Quality Paper and Plastic Products. Despite repeated demands by Lim, Arco Pulp and Paper did not pay. So now, Lim filed a complaint for collection of sum of money with prayer for attachment with the regional trial court. The trial court rendered its judgment in favor of Arco Pulp and Paper and dismissed the complaint, holding that when Arco Pulp and Paper and Eric C. entered into the Memorandum of Agreement, novation took place which extinguished Arco Pulp and Paper's obligation to Lim. Now, what happened was the CA reversed the said decision. So, we are faced with the issue of whether or not the obligation between the parties was extinguished by novation. The court ruled that the obligation was not extinguished by novation, that the obligation between the parties was an alternative obligation. Okay? So, here, Pulp and Paper had Pulp and Paper had an alternative obligation whereby it would either pay Dante Lim the value of the raw materials or deliver to him their finished products of equivalent value. When petitioner Arco Pulp and Paper tendered a check to Lim in partial payment for the scrap papers, they exercised their option to pay the price. This choice was also shown by the terms of the Memorandum of Agreement, which declared in clear terms that the delivery of petitioner Arco Pulp and Paper's finished products would be to a third person, thereby extinguishing the option to deliver the finished products of equivalent value to respondent. The trial court erroneously ruled that the execution of the Memorandum of Agreement constituted a novation of the contract between the parties. Take note that novation extinguishes an obligation between two parties when there is a substitution of objects or debtors or where there is subrogation of the creditor. The consent of the creditor must be secured for the novation to be valid. In this case, Lim was not privy to the Memorandum of Agreement, thus his conformity to the contract need not be secured. At any rate, if the Memorandum of Agreement was intended to novate the original agreement between the parties, respondent must have first agreed to the substitution of Eric C. as his new debtor. Okay, so that would be all for this video regarding alternative and facultative obligation. Please don't forget to like and subscribe for more videos.